Iacobucci, and I'm an attorney at the law firm of Weiss and Mattei. We have offices in Phoenixville and Pottstown, but I work out of the Phoenixville office. A little bit about myself: I'm from Phoenixville, grew up here, I live here, and now I work here. So I went to this library growing up, so I'm intimately familiar with the area. I practice exclusively family law, which is more than just divorce. It is divorce, custody, support, child support, protection from abuse, there's a couple other sub areas. If you're interested in custody, I have a workshop next Monday at the same time where I will be talking just about that. I guess I should say one more thing. My firm is not just a family law firm. I practice family law, and that's all I do, but we have other attorneys who do trust and estates, business, real estate, litigation, criminal. So if you have other needs, John always can say could help you with those. All right, so what are we going to talk about today? We're going to talk about divorce. We're going to talk about something called equitable distribution, and we're going to talk about alimony. What are we not going to talk about today? Child support, custody, and how you can go file a divorce complaint on your own. I will not be going through the steps of how you go to the courthouse and file the paperwork by yourself. It's, quite frankly, it's complicated, and it's really not the purpose of the talk. If you have specific questions, I'll entertain them, but mostly we're going to be talking about the law today. That being said, we're talking about Pennsylvania law. Family law is state specific. So family law in Pennsylvania is different than, technically different than New York, New Jersey. There could be similarities, but everything we're talking about today just pertains to Pennsylvania. Divorce. There are fault ground types of divorce. Fault and no fault. When you file for divorce in Pennsylvania, you have to establish there's been fault. There are, as you can, and I've listed the grounds for fault: willful and malicious desertion, adultery, cruel and barbarous treatment, bigamy, imprisonment, and indignities to the innocent and injured spouse. Guess what? Everyone in this room has indignities to the innocent injured spouse. Okay? That being said, Pennsylvania is a no-fault state. So you don't have to establish fault to get a divorce in Pennsylvania, and rarely do you. You might once in a while a client will come to you and say, I wanna establish fault. I wanna proceed on those grounds. All right, so you want to have a hearing where in front of a judge and tip staff and an audience where you put on a trial about adultery or bigamy. Doesn't happen anymore. Almost all divorces in Pennsylvania proceed as a no-fault divorce. No-fault divorce, we have two kinds. We have mutual consent, and we have irretrievable breakdown. Mutual consent is pretty much what it sounds like. You and your spouse agree you want to be divorced. But there's something called a 90-day waiting period. So you come to me and you say, my husband and I, we agree to everything. We know how we're going to split it. We already have an agreement as to how we're going to split the assets. I'm ready to file. Great. We still have to wait 90 days. Before you can file what's called an affidavit of consent, thereby establishing that you have grounds for divorce. On the opposite end of the spectrum, we have irretrievable breakdown, which is the marriage is irretrievably broken and the parties have lived separate and apart for a period of at least 1 year. So in that situation, a party says that they want to get divorced, but their spouse doesn't. Can I still get divorced in that situation? You can, but you have to wait a year to establish grounds. And during that time, you have to live separate and apart. After a year has passed, then you can file the appropriate paperwork that says, we have lived separate and apart, and I want to move forward. At that point, the spouse can no longer fight it. They can fight it, but it becomes it's difficult to prove. I've bolded the language separate and apart right here. Oh, I'd also like to say one thing. You might be thinking, wait a minute, I thought there was a 2-year waiting period in Pennsylvania. A year ago, December, Pennsylvania went from a 2-year to a 1-year waiting period, which has basically sped up the rate at which people can get divorced quite a bit. So, separate and apart. What does that mean exactly? Does it mean you have to live separate houses? Does it mean separate bedrooms? It means that at least one spouse has clearly, obviously, and intentionally communicated to the other spouse that he wishes to completely stop living as a married couple. Well, how can you prove you are living separate and apart when you live in the same house? So often, I would say often, so a party will come to me and they'll say, well, we're separated. And if that spouse has moved out and they're living somewhere else, then that's clear. They're clearly separate. They no longer live together. But people can't afford, in a lot of cases these days, people can't afford to float a rent and a mortgage. So they can't afford to move out. They don't have that extra income. So what they do is they go to a different bedroom, go to the basement, whatever the case may be. But there are reasons why the other spouse could claim they haven't been separated. So in that situation, you have to, there are factors by which the court will look at that will show that you are, besides saying the fact that, well, I told my wife I want a divorce. All right, well, what else have you done? Do you have separate bank accounts? Have you filed your taxes separately? Have you told your family that you're not with your spouse anymore? Here's the question that I always say to my clients. I said, what do your friends and family think you are? Do they think you're separated, or do they think you're still married? And that's usually what get people thinking about if they're really separated or not. All right, so that's after we've established that we have grounds, either through mutual consent or irretrievable breakdown. Now we get into equitable distribution. General rule. Upon the request of either party in an action for divorce, the court shall equitably divide, distribute, or assign, in kind or otherwise, the marital property between the parties without regard to marital misconduct in such percentages as the court deems just after considering all relevant factors. The court may consider each marital asset or group of assets independently and apply a different percentage to each marital asset or group of assets. Let's break this down for a minute. Does anyone see the word equal in here? I'll tell you if there's no equal, okay? I see the word equitable. I don't see the word equal. Does it say that if you cheat on your spouse, you get less than you think that your spouse deserves?
No.
I don't see that either. I say without regard to marital misconduct. What do you usually hear? Well, my spouse cheated on me, so I don't think they deserve anything. I wish that was the case. It's not. And that's not, and unfortunately I say to people, that's not me, that's the law. So, equitable distribution is the method by which we take your marital estate and we divide it, okay? We divide what's called marital property. Well, first, there's 3 basic steps to equitable distribution. First, we have to identify it. What counts as marital property in your estate? Then we got to value it. And how do we value it? And thirdly, we have to distribute it. Who receives that property that we've identified and valued? First up, let's identify. General rule. All property acquired by either party during the marriage and the increase in value of any non-marital property except if. So these are the exceptions to marital property, okay? Property acquired prior to marriage or property acquired in exchange for property acquired prior to marriage. Property excluded by valid agreement of the parties. Prenup, postnup. Property acquired by gift, except between spouses, bequests, devise, or descent, or property acquired in exchange for such property. Well, my husband's aunt left him a lot of money while we were married, and okay, well, did she leave it to both you and your spouse? No, she just left it to my husband, and he put an account in just his name. It's not marital property. The increase in that inheritance is, but the actual inheritance is not. Property which when a party has sold, granted, conveyed, or otherwise disposed of in good faith and for value prior to the date of final separation. While you guys were married, your spouse sold a couch and got money for it. The couch is gone. You have the money, okay? Veterans benefits. Property to the extent which property has been mortgaged or otherwise encumbered in good faith for value prior to the date of final separation. We'll come back to that one. Any payment received as a result of an award or settlement for any cause of action or claim which accrued prior to the marriage or after the date of final separation, regardless of when the payment was received.
Can I take a picture of your son?
Sure, but are we posting it somewhere?
Mm-hmm.
Oh, yeah.
We are? Okay. But I don't care if you take a picture either. And, that's fine. I'm dealing with a case right now where husband was hurt at work. During the marriage, we're talking about during the marriage, husband was hurt at work, and as a result of the injury, he filed a personal injury claim. Okay, he lost a finger. He received a personal injury award of $175,000. Okay? But he settled the case. He received that award after the parties separated. Is that money marital or non-marital? He was injured while they were married, but received the money after they were separated. I didn't tell you I was quizzing you, so I won't. But it's marital, okay? It's marital money. Much to his chagrin. So, all right, let's talk about that. Marital property presumption. All real or personal property acquired by either party during the marriage is presumed to be marital property regardless of whether the title is held individually or jointly. Okay, so that basically means that a piece of property is going to be presumed to be marital, assuming you acquire it during the marriage. And if your spouse is going to claim it is non-marital, the burden is on him to prove it is non-marital. Timing controls over title. Well, my pension or my 401k is just in my name, so that's just mine. No, it's not. It's marital. Any title does not matter in Pennsylvania. Your house could be just in your name, the mortgage could just be in your name, but you lived there for 20 years as a couple, that's a marital piece of property. I pretty much touched on the third bullet, which is if you're claiming property is non-marital, burden is on you to prove otherwise. Value marital property. As I said, as I tried to make the point earlier, equitable does not mean equal. Pennsylvania is not a 50-50 state in the sense that it does not automatically mean that upon divorce you will be awarded 50% of the marital estate. The courts or your attorney can fashion an agreement whereby estates are divided 45-65, 40-60. It's really dependent on a lot of factors how the ultimate distribution is made. But it's really important that you understand that it's not always 50-50. The other thing I wanted to mention about valuing marital property is sometimes it's easy in the sense that let's say you have a bank account, you're looking at you have statements, all of you have statements for your bank accounts, okay? And as a date of separation, you're gonna have a statement that will show me what's the value in that account. So documentation is really important in divorce. You're going anything that you say has a value, you need documentation to back it up, okay? But there can, and I don't want to go too much into this unless you have specific questions. There are other things that are a little bit more difficult to value. For instance, you could get a house appraised. You might think your house is worth $500,000. Your spouse might think it's worth $400,000. So you're gonna have to find an appraiser and get it appraised. He's gonna say, perhaps he'll dispute it and get his own appraiser. It's up to the court, or whether you and your spouse agree otherwise, to come to some agreement as to what you're willing to put on as a value. Otherwise, the court will assign a value. That being said, I will say this about divorce. Everything can be agreed upon. You never have to step foot in court. You and your spouse can agree to everything. Divorce, custody, support. The courts only become involved if you and your spouse cannot agree. I would say most cases get resolved out of court. Why? Because it saves you a lot of money. So especially equitable, these sorts of things like equitable distribution are things that are solved out of court, because it's easier to put a value on, identify, as long as you and your spouse can agree this is what's in our marital estate. A 401k, some bank accounts, a house, some cars, and you can put some values on that. You and your attorney can work with the other attorney to reach some kind of agreement. Because you know why? They know your attorney is going to know what a court's going to do, and they'll be able to advise you that and say, well, listen, the court's going to do this anyway, so why don't we try to reach an agreement without going to court? So I think that's important to understand, that you never have to go to court in family. You never have to go to court in a divorce. It's only the pretty much your last ditch effort, or the last option. All right. Let's say you do end up in court. What factors are taken into consideration when you divide marital property? Length of marriage, any prior marriage of either party, the age, health, station, amount and sources of income, vocational skills, employability, estate, liabilities, and needs of each of the parties. The contribution by one party to the education, training, or increased earning power of the other party. The opportunity of each party for future acquisitions of capital assets and income. There's more. The sources of income of both parties. I won't read the rest of that. The value of the property set apart to each party. The standard of living of the parties established during the marriage. The economic circumstances of each party at the time of the division of property is to become effective. The tax ramifications associated with each asset to be divided, distributed, or assigned, which ramifications need not be immediate and certain. The expense of sale, transfer, or liquidation associated with a particular asset, which expense need not be immediate and certain. Whether the party will be serving as the custodian of any dependent minor children. As I was going through these, I thought of one thing that is usually something that comes up that you might not think of. But with K, the expense of sale, transfer, or liquidation associated with a particular asset. If you have a house, a marital house, and you get it appraised, let's say you appraise it $200,000 or $500,000, okay? The value of that house is the appraised value minus the mortgage, okay? But guess what also comes off that appraised value? Even if you're going to keep the house in divorce, 7% for cost of sale. So you take off 7% cost of sale, the expense of sale, even if you're keeping it, the courts these days are taking it off 7%, and the mortgage. So it lowers the actual value of the house when you take off that 7%. All right. Now we're going to get into alimony. General rule: where a divorce decree. Oh, I just want to say one more thing. What did I not see on equitable distribution factors? Misconduct, marital misconduct. Just feel like I need to highlight that. Alimony. General rule: where a divorce decree has been entered, the court may allow alimony as it deems reasonable to either party only if it finds alimony is necessary. Well, let's break this down. The court may allow alimony. Doesn't have to. Necessary. Alimony is not a given in Pennsylvania. I have to stress that. Just because you are getting divorced and you might not be the breadwinner does not mean you are entitled to alimony. But how do you know if you might be entitled to alimony? Here are the factors Pennsylvania considers if you're looking at alimony. The relative earnings and earning capacities of the parties. The ages and the physical, mental, emotional conditions of the parties. the sources of income of both parties, including but not limited to medical, retirement, insurance, or other benefits, the expectations and inheritances of the parties, the duration of the marriage, the contribution by one party to the education, training, or increased earning power of the other party, the extent to which the earning power, expenses, or financial obligations of a party will be affected by reason of serving as the custodian of a minor child, the standard of living of the parties established during the marriage, the relative education of the parties and the time necessary to acquire sufficient education or training to enable the party seeking alimony to find appropriate employment, the relative assets and liabilities of the parties, the property brought to the marriage by either party. We have a lot here. The contribution of a spouse as homemaker, the relative needs of the parties, the marital misconduct of either parties during the marriage. The marital misconduct of either of the parties from the date of final separation shall not be considered by the court in its determination relative to alimony, except that the court shall consider the abuse of one party by the other party. So basically, if you separate and you start dating someone, that's not marital misconduct. Anything that had to happen while you two were married. The federal, state, and local tax ramifications of the alimony award. Whether the party seeking alimony lacks sufficient property, including but not limited to property distributed under Chapter 35 to provide for the party's reasonable needs. Whether the party seeking alimony is incapable of self-support through appropriate employment. Okay, so why don't I give you an example of a case where there's alimony involved, because I'm dealing with it right now. I think it's about a 15-year marriage. Parties have been married for 15 years. Wife was the caregiver for the children and did not work for the duration of the marriage. Husband was the primary breadwinner. Wife has very little on her, little, if anything, in terms of retirement. And the job she makes now is probably $15,000 a year. Husband makes good money. He has the prospects of making good money well into the future. They have 2 kids, and I'm probably thinking of a couple other factors. For that, we're looking at, and like I said, it depends. She is looking at 5 years of alimony, okay? But she has a lot of these factors on her side. And husband is motivated to settle the case. So he is throwing up some additional money. I think there was anything else. All right, so if there was anything else I wanted to say about any of this. The other thing that Pennsylvania does when it comes to alimony is you'll find that courts will say, well, if you're getting a larger portion of the estate, then there's not going to be alimony. So in many cases, if you have a marital estate and you're going to divide, if the wife is going to receive 60% of the marital estate, she's looking at little to no alimony. If the wife needs money coming in, if she needs alimony, and I always say, I'm sorry, I don't mean to always say wife, it's just, I guess it's habit. Then perhaps she would say, I'll take 50% of the marital estate, but I want some alimony. You rarely will get a big portion of the marital estate in addition to and alimony. You rarely get both. It has to be pretty dire circumstances to get both. Happens, but it's rare. So that was my presentation.